I guess that's true.
All right, we are live.
Okay, it's 5 after 5 and the Ethics Commission is called to order and it's Monday, May 17th. This is a Zoom meeting and the agenda had been previously published. And are there any changes to the agenda that we need to make?
I have none.
Okay. I'm going to put to other business as needed the advisory opinion that we had to withdraw. On summary of recent activities, I'll start with the oldest, which was on March 22nd. And it was a city council meeting where they withdrew resolution 4-21, which was to form a commission for ward boundaries. It was decided during the meeting that resolution was inappropriate because you could not form commissions under resolutions. They had to be done by ordinance. We had an interest because we received a concern, or I'll say a complaint, I guess, asking if one of the people being appointed was the wife of an alderman. Turns out that it was not a wife. It was the sister of an alderman, and the resolution was removed. Therefore, we had no action on it. On April 23rd, we got a complaint as far as a potential conflict of interest for the Planning Commission. On May 5th, I had a meeting with Mike Lyles, the city attorney, where we discussed a number of issues. Number one, how he assigned work within the Office of Law. Number two, he had offered to assist us in any way that we needed. And he had explained that his priorities were for, I actually have to look at the memo. I did document that in the memo. His intent is to avoid conflict and encourage harmony within the office and the working environment. And he desires to work on principles and concepts and leave the other concerns to his staff. And the latest was on Saturday when Vincent gave me a call and said that he was going to resign from the commission because of heavy workload working for the county. I told him the process would be to send an email or a letter to the mayor with a copy to Hillary and myself. Carrie, I assume that was the proper guidance?
That's correct. And before I forget, I kind of want to go back on that commission that you first referenced at some point when you're done going over things, because I have an update on that I just discovered.
Okay, this is an appropriate time. Go ahead.
Sorry, I didn't want to interrupt, but I wanted to put it out there just in case I forgot myself. I just pulled up the legislation and they did continue on the with a new piece of legislation that was a resolution. And instead of it being a commission, it is now a task force that is studying the ward boundary and redistricting. And it looks like listed on the membership of the task force, the individual who was first sort of flagged, if you will, is still on that task force. So I'm not sure if the Ethics Commission is still interested in potentially looking into that. My understanding was that it was the sister of an alderman and was sort of assigned to Ward 7, I believe, but I would have to double check and see in the emails that I have from a couple months ago.
I believe she was a resident of Ward 7. And we'll see if anything comes up for us for it. I don't think we have any action unless the woman who asked the question comes back to us.
Can you define what a task order is? Task order. Stuck on contracting today. What a task force is. Is it defined in the code, or does it fall under?
I don't think it's defined in the code. I mean, in this instance, it looks like all references to the word commission were removed and replaced with task force. So they would be doing the same functions that when it was named a commission, that the commission would have been doing, which is reevaluating the boundaries and things of that nature. But as far as a formal definition of task force, I'll double check, but I don't think it's defined in the code anywhere.
So does that mean it does not fall under our purview is my ultimate question. Because the code defines our purview.
Yeah, you might be right on that.
Maybe why they did it. Yeah, in my mind, the difference between a task force and a commission is more permanent in nature generally, and a task force is generally more limited. But I think you could use them interchangeably as well. So it's interesting that they made the conscious effort to change the term.
Well, so my understanding is that the reason why they changed it to a task force is because of the charter. To create a commission, you have to go through revisions to the charter and amend the charter. So it was sort of not a means of circumventing potentially the Ethics Commission's authority, but it was more so to get this task force up and running before the election. And they're on a little bit of a time crunch. So it was to avoid having to go through the whole amendment process of the charter. I mean, I just did a quick search in the code and task force. The term task force is only mentioned twice. So I'll look and see if there's anything that sort of exempts that from your guys' authority. But carry on and I'll jump in when I see something, if I see something.
Thank you.
Thank you, Carrie. Next on the agenda is review of the process for obtaining financial disclosure statements. At our last meeting, we had decided that we were going to I'm losing the word. Subpoena the non-compliance to appear before us at this meeting. I wasn't able to do that because of difficulties in setting up the meeting where we could keep privacy and we could setting up times for people to be here, and it just wouldn't work in the time frame. I do have status as far as the number of people who have not provided financial disclosure forms, and that's 30 employees, 16 board and commission meeting members, and there were 12 statements of compliance that were not executed. In addition, there's one alderwoman, Sheila, and two aldermen, I should say, Sheila and Dewan, and also Chief of Police Jackson and Michelle Johnson, Public Works Director. So there are 4 senior people who have not completed, who have not filed financial disclosure forms. And my recommendation is that you support me in going to Mike Lyles and requesting his assistance in getting them to file the financial disclosure forms. Karen has done her thing, multiple emails. I've tried telephone calls to the two of them. That hasn't worked. I think Mike will be willing to contact them and just mention as a courtesy that they're overdue.
Couldn't Trisha Hopkins take the lead on the employees?
Well, for the employees, in discussing this with Karen, she would like to send an email to the, that is another email to the individual with a copy to the supervisor.
I would recommend also copying the Tricia as in charge of HR. If this was a company, I would be recommending that HR would step in at this point.
You think it's an HR issue as far as them being in compliant with an ethics code?
Well, it says that they have we work with them on reviewing the ethics code or the ethics instructions every year. I think that she'd be more than willing to participate. And it is, I assume it's part of their employment.
Well, that could work.
You know, I think that in addition to the four senior people that you're talking about, I would recommend a formal letter from the chair to them in, hard copy, delivered to their to the city hall or to wherever they work.
As far as the four senior people?
Mm-hmm.
And not ask the assistance of the city attorney?
I think that the city attorney could be brought in after a formal letter. And I think that, the supervisor of those people, the mayor should be copied for the alder people and for the chief of police and the public works should be copied to the city manager.
Jean, your thoughts?
You've done repeated outreach to these folks, Jim?
I have not well, I've reached out to the alderman.
Okay.
I did not reach out to the chief of police or the public works department head. And that was by telephone, which is almost hopeless.
Right.
Nobody answers the phone anymore.
And it's almost the same thing with email. That gets to be hopeless also.
Yeah. I would think.
I like your idea, Kevin. Jean, I'm sorry to interrupt you.
No, that's okay. I think a letter to them.
I'll volunteer to hand deliver the letter to the police department since it's right down the street from my house.
David, your thoughts?
You're on mute, David.
Insofar as the CC to Tricia?
Well, I guess your thoughts on all three ideas.
My sense is it doesn't cost us extra to CC somebody if it gives us some leverage. That's fine. And I think anything we can do to leverage makes sense, and particularly since nothing that we're talking about is overly burdensome.
And COVID is over. Everybody's back to work.
I don't know if it's true for the city, is it, Carrie?
Our office in particular has been back full-time. There's a few, obviously, like public safety that never worked from home, but in a general sense, I'll tell you, HR is still teleworking and a few other departments are still teleworking, but Michael Johnson, the Director of Public Works, he's in the office more times than not, and the same with the Chief of Police.
I mean, the people have been working, even a year ago, last May, people were all working just because of their physical location. Doesn't matter. By the time it's been a year since we as a city has figured out how to do the city's business with the restrictions that we have. City is still running. Taxes are being collected, money's being spent, life is normal. There should be no excuses for not filing code required statements and financial disclosures, especially in an election year.
I was gonna say, it's in their own interest to do it.
Particularly the alderman, yes.
Yeah, and we need to continue to do our responsibility to the code and, get them, it's been a couple months.
So it's consensus that I should send a letter.
Yeah.
To
The letter for the top four, and then the other for the employees, CC their manager, or Karen can do that. The CC their manager and the Tricia Hopkins, and then for the boards and commissions, the chair of each commission should be CC'd on an email.
Yes, and that's clear. We'll do that by email. Now, should I ask Karen to include a copy again of the financial disclosure form?
In an email, I would send a link,
Yeah.
Because I don't-
link to the, yes,
but because it's much easier to fill it out. If they're doing an email, they're reading email, they should be able to get to the site and use the fill in. It makes life easier for them. But I don't think we should provide a copy to the two alder people and chief of police and public works. They have computers.
Can I make a suggestion as it relates to the Chief of Police? If you're sending an email, you may want to copy his assistant as well, because she's the one that generally checks his email and she'll kind of be on top of it. I'm not sure if that's who Karen was communicating with before or not, but she usually.
thank you, but I think we agreed to send a letter.
Okay, well, you were just talking about an email, so I wasn't with a link, so I wasn't sure if that was also going to be going to the two appointeds and the two electeds.
No, that's been done in the past by Karen. As far as using email for them.
Okay.
I think I'm clear as far as what we'll do. I'll send letters to the four senior people. I'll copy HR and the city manager and the mayor in the case of the alderpersons.
Thank you.
Are you gonna send a letter to the alderperson, Jim?
Yes,
Might it be worthwhile to give them a call first and say
I
this?
tried.
Then you never got a call back?
No,
Okay.
never got a response. And in the case of Dewan, I think his voicemail was full. And so they're really hard to get a hold of them, which is amazing to me since their
Yeah.
constituency is the public.
No,
Okay, is that clear?
Mhm.
that doesn't work. We can go to city council and open comments, say it. That might be a little too far.
That will be gentle.
Yep.
Any further discussion?
No,
Mm-mm.
thank you for keeping on this.
The next item on the agenda is a review of the procedures for conducting Ethics Commission business. But I would like, with your concurrence, for the purpose of Ashley, who has joined with us, that we change the agenda at this point and move her area relative to the review of code, the code requirements for a statement of compliance. Is
So
that
you,
acceptable?
if you want to make a motion to move item 4 ahead of item 3?
Yes, it's a courtesy, Ashley. I so move.
Second.
Second,
Those in favor or discussion? Those in favor?
aye.
Thank you. Ashley, you did an excellent paper as far as identifying state law impact on our requirement for statement of compliance. It looks like we don't have any choice but to allow the Office of Law to draft legislation or draft an amendment to the ethics code to remove that position, which is paragraph 2-08060. And you're muted, Ashley.
Yes, that's just because I have kids in the background, so there's a lot of tangent noise. But what would you like to know from me that wasn't in my memo? Or did you want me to briefly explain the memo?
If you could do it very briefly.
Okay, so brief version. The Maryland Constitution sets out an oath that is to be used by all officers and officials in the state of Maryland. The Maryland Declaration of Rights adds that this oath is the only one that can be used. The same oath language is mirrored in our city charter for use with all elected officials, appointees, including boards and commission members. So the problem with the statement of compliance is, even though it's called a statement, in legal parlance, it operates like an oath. It is requiring certain behavior and or actions from the boards and member commissions. And if they refuse to sign it, then similar to refusal to take an oath, then they are not appointed to the member or commission position. So I did some case law research and I found similar cases where the state or other local jurisdictions had tried to add a second oath or statement, and each time it got knocked down. So my recommendation is that the statement of compliance needs to be removed. However, I know the purpose behind it was to try and get sort of a quasi-financial disclosure sort of affirmation from lower boards and commission members than the ones that are specified that have to fill out the financial disclosure form. So my recommendation was maybe you do a shortened financial disclosure form for these types of members. That is within your authority. I know it would add somewhat to the case load for you guys to review, but as long as it operates as a financial disclosure form versus a statement at the beginning that they have to sign off on before taking position, you could maybe capture some of the same information you were trying to affirm through the statement. So that was my alternative recommendation.
That's intriguing, but my opinion is that, based on past discussions, that this was put in to ensure that they have a tickler to say at the beginning of their work with the city to understand that there's an ethics code and there are, codes related to finance as well as other ethical behavior that was being kind of reminded of. So I don't know if we actually have a desire, I don't know if we have a desire to garner financial interests or financial information on a yearly or a one-time basis.
The other thing is you could just provide the statement and the information, but the problem is if you are requiring them to sign off on it before they can take position, then it becomes an oath. So you could still send out a statement with an informational packet saying, we want to make you aware of all of these things, something of that nature.
Could we make them acknowledge receipt of the document?
You can try, but again, you're getting into that gray area where if they don't acknowledge it and you say they can't take their position, then in essence, it's operating more like an oath than anything else.
Correct me if I'm wrong, Jim, you were on the commission when it was first, the statement of compliance was first put in. I think David, you were too. Right?
I don't remember past yesterday.
It was in 2012, as far as I can tell, based on my research.
Right. So in that, Jim, I remember you said at one time to me that it was at the direction of the current city attorney.
Yes, and from the perspective that financial disclosure forms were not required of anyone other than quasi-judicial commissions and boards.
Right. I mean, I completely agree. You know, obviously your legal opinion is complete agreement with just get rid, it has to go. But do we really need to backfill it with something? I mean, if we pass out a document that, have, like you were suggesting, Jim, is a document like what we do for the employees. It's just kind of high level guidance. You get up there, you certify when you're gonna abide by all the code, including the ethics code. They are, they're adults. They know what they're doing when they raise their hand and certify they're going to withhold all the laws of the U.S. Constitution, the Maryland Constitution, and the city charter. What more do we need to do?
My suggestion was, as we do with new employees, that HR provides an ethics guide, which is a plain English
Right.
version of the ethics code with a Q&A format, that we do the same thing and have it handed to the people when they are sworn in.
And put that onus on the chairs of all the boards and commissions?
The chairs don't swear them in. The
Mayor
mayor
does.
does. Am I correct on that, lawyers?
Yeah.
So,
Yeah, it's usually either mayor or the city clerk. Yes.
so if we made it now the city clerk is a member of the mayor's staff or the law office.
Law office.
So if we made it a requirement to provide that additional information to the appointee, it should be done by the mayor or the city clerk, right?
Well, who currently sends these new people the statement of compliance?
Oh, Karen does that on a one-time basis for any commission or board member.
Can we just swap out one for the other? We're not adding a new process. We're not changing we're not adding another process to the city council, the city clerk, or to the mayor's office. The law office has a process. Instead of sending this PDF out, they send out the same document we use for HR. We can tweak it to be both, and it can go out. She doesn't even need to follow up with them. We're reducing her load. And Bob's your uncle.
provide the copy and that's the end of it.
Yeah. And I don't think we need a signature to say that they got it. You mean, we, you know, they all swore they're gonna uphold the code. I assume that people who swear they're gonna uphold the code in the Constitution and the Maryland Constitution have actually read it. I have. You know, I love lawyers, not, prosecutors always say ignorance of the law is no exception.
David, your thoughts?
I like the idea, I'd like to keep it simple. And I like the idea of having the provisions or document handed to the appointee commensurate with them being sworn in. Because they're all going to take an oath.
Regine,
I like the idea of just swapping out what we used to send out with this. And call it a day. Because, no, Ashley?
No, that was not for you. That was for my 3-year-old. Sorry.
We saw his hair go in and out.
It's like, oh no. Yes.
No, that's fine. That was for my.
Because I think that, Dave, I like the simple thing, but I think that's simpler than having another thing at swearing in.
And swearing is more, I would say, more pomp and circumstance. That's where you get your picture taken and you get your pin, and it's just something that's going to get lost. Because no other code is provided to them at that time.
that is true. David, would you go along with that?
What's that are we doing just sending it to them, or are we going to do it? Are we talking about doing it commensurate with the oath?
Just sending it to them as a new appointee.
I'm comfortable with that.
Okay.
It's easier than the oath piece.
Yeah.
I don't think we need to vote, but my determination is that is our consensus.
Yes.
Yes.
Consensus is good.
I'm
Thank you again.
going to mute myself. I have to call my accountant back. A little bit late on my income tax return.
Dude, it's due today.
You're joking.
So,
Extensions are easy. Ashley, thank you very much. I don't think we need your help any further.
All right. Let me know if you need anything else. Have a good meeting.
hey, just a tip for you, Ashley.
I just thought of something. The memo was to me from the city attorney, and I apparently have an action to get back to him.
Yes, I think you need to let them know to move ahead with repealing that section.
It's the bewitching hour.
Wow. It's only a week in mental time from that to writing a deposit check for Tulane.
Yep.
Okay, I will do that, Ashley. Thank you.
You are welcome. Have a good one.
All right, bye.
Bye.
Hey, Kevin, real quick, I just looked up on the city code to look up and see if what your guys' purview task force is.
Mhm.
And definition of official includes an employee or a person appointed to or employed by a city agency, board, commission, or similar entity. So I would say task force would be considered a similar
Okay.
entity.
Good.
Good.
It's good to know. Thank you.
You're welcome.
Next item on the agenda is review of procedures for conducting ethics commission business, which we all have. A little history on this. It was put together in the spring of 2016. And I believe David and I are probably the only ones that were on the commission at that point.
No, this was the first thing I worked on.
Oh, good. So we have all three of us, except for Pagine. And it was drafted by Jerry May, who was an attorney on the commission at that point. And he was very, very determined to have detailed process within our procedures. In trying to follow the procedure for this most recent complaint and not having an expedited process called out, my conclusion was that the procedures for doing our business were really too detailed and too restrictive as far as what the code requires. Many parts of it are a repeat of what is in the ethics code, and parts of it are further explanation of what's in the code. I would love to get it down to a 1 or 2 page document. Opinions, please.
It's my opinion that this we have used this 6 or 7 times since May 16, and it seems to I like the detailedness in one document. I think that with regards to we ran into some issues with expediting something. I think we were kind of a victim of the remoteness, which we should not have been, but we should continue to follow this procedure, just kind of be a little mindful of how to make it better with us all being remote, which ending soon. But if it happens again, I don't want to give up the detailedness for doing things expedited. Does that make sense?
Makes sense to me. And Pagine, since you were the initial presenter for this, for the latest case, how do you feel about it?
So I think Kevin's right. I think we got a little sloppy. And we should, fess up to that. But I'm still not clear about the pre-hearing and hearing procedures. So after receipt of an answer to the charging document, so that's after we send our letter to the potential violator.
So what?
I don't
Sorry, what
understand the
section are you
hearing
in?
process?
What
I
section?
mean, section 6.
C6.
Yes,
Right.
this is where I'm confused what we missed.
Well, I think that we may have inadvertently combined a request for opinion and guidance and a alleged violation together.
Well,
Well,
think-
to sort of be clear that it was actually a complaint that was filed. So it was
Right.
sort of a complaint that turned into a advisory letter is what the kind of outcome was, but it wasn't, it was a complaint that was filed initially.
it wasn't
Right,
a
so we
request
did
for
not-
advisory.
Yeah, so we did not follow our procedures correctly. So I think that would, that kind of leads me to more of the opinion we shouldn't, go and hastily try to redo this. But I think that we could walk through the section that at the later date as a kind of a working group, if we want to, or maybe one-on-one with what the procedure is. Then, or we could have, should have had a more, I'll call it seasoned, but somebody who's gone through it before to, and then have Begin be the kind of ride along.
Because since I've been on the commission, we've never done a complaint. It's
Right.
always been these advice.
Good, Gene, that's why you got it.
Right.
And I wasn't thinking, okay, I know how to do this, right? You look at the facts, you're right. You cite a few things and off you go.
Right,
And-
so, yep, so we did the right thing, we recalled it, and we need to make a decision, are we should start section 6 again. Sorry, section, C again.
Yep.
Yeah, if I can just point out, the city code only requires, if there's evidence of a violation or determination of a violation, to afford the respondent an opportunity to be heard. And then your rules of procedure kind of add another layer where there's an opportunity for them to respond in writing or kind of do some sort of written statement before it gets to the point where a hearing takes place. So I think that might be kind of what Jim was referring to with regard to it going a little bit beyond what's required in the code. I don't
I
want
have
to
a
speak.
different perspective. To me, in my mind, we should craft the manner in which we're going to consider a complaint based upon the unique situation of each complaint. I don't, if we create these very specific rules, they can often come back and bite us. And I think we don't get that many complaints. I think for every complaint we get, the chair can recommend the manner in which we're going to consider it. And as long as it comports with the statute and it has the support of the majority of the commission, then I think we can proceed with that method and advise the parties in that manner. Because creating all these procedures, I think, and we can still use it as a guide for some issues, but I just don't like the sense of being tied into something that's this specific. And in a sense, that's how courts handle hearings often. They have a pre-trial where they set out the rules of the manner in which the hearing is going to be conducted.
So, but it says here, if the complaint is not dismissed, a hearing will be scheduled by the commission.
That's in the statute.
Okay.
Yeah, so if, we're duty bound to have a hearing.
Okay.
Yeah, the statute says that the parties shall be afforded an opportunity for a hearing. So there could be a situation where you guys inform a respondent and say, we found a violation, and they don't necessarily want to proceed to a hearing. That's not what happened in this last case, but there is always that possibility, as long as they're afforded.
The other question I had is, we got the complaint and it was very detailed, right? Do we have an obligation to share that with the person who's been complained about?
The answer to that, I believe, by the procedures and the code both, is yes, a copy of the complaint is to be filed with them.
Yeah, because I think that's an important thing. Also, when it was pointed out we didn't do that, I was like, oh, well, that's kind of like shooting in the dark if you don't know what's being said about you.
Yes, exactly.
Well, that's section C.
Two,
C3.
3, okay.
Yeah, the initial procedure at the bottom of it, the complaint is not dismissed. The chairperson shall notify the complainant and the person against whom the complaint has been lodged. A copy of the complaint shall be provided to the person against whom the complaint has been lodged. I thought that was what we were talking about in the code. So I understand what David is saying about, pretrial hearings and all that, but the purpose of us putting this together was that it was a standard that we could publish and put out there. If we go beyond the code, we can talk about taking something out. But I like the idea of a standard because boards and commissions change, right? We're not all going to be here, and the next group needs to have it. And
one of the mistakes we made was that we didn't adhere to our process in that a complaint can be either dismissed or, oh goodness, I'm drawing another blank.
Or upheld.
Or concluded with a, help me here.
Like a finding of fault.
A final determination. That's
right.
So those are the two choices we have, and we didn't issue either of them. And so we will hold a hearing, and I will invite both parties to participate, and we'll take it from there. And by the way, the date for the new hearing will be June 2nd, which is a Wednesday.
Well, don't we have to issue a charging document?
I think we can avoid that at this point from the standpoint that we've acknowledged the complaint.
Is the charging document required in the code?
No, that's an additional sort of layer.
Okay.
Along with, I think it was a 30-day opportunity for the respondent to reply to the charging document with their answer. But those two parts are not required by code.
Right, but here's the issue we have. We're in flight. Right? We had, this document was part of the public record, let's call it, when this complaint came in. So we're in flight. We need to follow the procedure because we'll be even more criticized and could be found at fault if we don't follow the procedures that we have in place. So it appears to me that we need to do a complaint charging document.
And to me, this evidences the problem with our procedures. I mean, it's pretty clear what this case is about. And to me, it's kind of perfunctory since there really is no contested facts, but we have all these hoops which we have to go through in order to have the complaint heard, and not adhering to them, as Kevin observes, can create issues with the efficacy of our decision. And that just rewinds to my thought that I think it would be better if we tailored the procedure to the nature of the complaint. I mean, this is not the complaint at bar now before us is pretty perfunctory because we have a hearing that was held. We know exactly what happened. There's no factual dispute here, or I doubt there can be. I don't know what the dispute could be at the hearing.
Either. I think it's a neighborhood dispute, to be honest.
Could be, yeah.
But I agree, but I think we need to make sure that we keep the horse in front of the cart. We need to finish this one. And if we want to revise the procedures, we should have that deliberate and contemplative effort.
Yeah. But you have to rewind, I guess, in this circumstance, the reason why this was expedited was because there was a hearing of the planning commission coming up on this matter. And I think, and the that to me bears evidence that our procedures would be a barrier to having an expedited consideration, which may be important in some circumstances.
Well, I think that we could have an expedited procedure in a couple of days. I mean,
But you just mentioned there's the 30-day response requirement. So my opinion is that if I was driving the train, I would just jettison these rules and just leave it up to the chair with the consent of the members.
but it says
Wait,
right
wait,
here,
let me finish, please. And have the chair with the consent of the members dictate how we're gonna consider each complaint. And it just goes back, we just don't get that many of them, so that wouldn't be a great burden.
I agree, but that does say in our determination, unless the commission directs otherwise, the respondents will have 30 days. We can change it. So, but we'll table that to the next part, to part 2, when we actually go through every line of this document, so to speak. But, we have a meeting. Well, not sure. Has the meeting been formally scheduled?
No. The hearing,
Yeah, the hearing, sorry.
the date that looks best for us is June 2nd,
At
What
5?
what time, Jim?
5 o'clock is what I said.
Could we do 5:30? Is that possible? We've already sent out the notice.
I have not sent out a notice.
I have
That was
something
for
at
discussion.
4, and I'd like to make sure to be on time.
June 3rd is a Thursday? Yeah.
June 2nd, Wednesday.
June 2nd, I'm sorry. Yeah,
And we can make it 5:30 if you all agree.
That's fine with me.
I'm
I
good
don't
with
think
that.
it shouldn't be a long hearing.
No,
It's pretty cut and dried, but again, we'll see what comes out.
yeah, I'm
Yeah.
sorry I
So,
caused this problem. And it did seem so cut and dry. I was all proud.
Yes,
I turned that opinion around.
you did good.
You did good, but
No spelling
It
mistakes.
wasn't really legal.
You were set up.
who would like to take a shot at the procedure? I think it should be a joint effort, but not necessarily done by all 4 of us.
Well, with my sentiment, I could do it very quickly. I could just put X's through the whole thing. So I don't think I'm a good candidate for it. And I I hope we do give
I
my
say
thoughts
we
some
table that
consideration.
until we see how this goes.
Okay.
Um, go
I
ahead.
think that we should put our efforts on this particular complaint, as well as put our efforts on the financial disclosures that are overdue. And then, we'll also have to participate with the city council when they take up this new code change. Because they're going to want to talk to us when we come in.
Of course.
And
Um,
yeah, let's just see how this one. Have you ever done these before? A hearing and a,
yeah,
Yes, we've done probably, since I've been on the commission, I think 3 hearings.
yep.
okay.
And
Are you guys still going to draft and issue a charging document? And give her the ability to provide her answer? And
I
maybe,
don't want to.
I
She
don't either.
asked for a hearing. Let's give her a hearing.
okay. Just because, that is still currently your rules of procedure, so I don't know if she's gonna bring that
Oh,
up, if she's
she
aware
could
of
be-
that, or.
She could take a reaction. Jean, what do you think?
Well, if it says a charging doc, well,
A charging document can be 2 sentences.
um, I think we can have a hearing without a charging document being issued prior.
No, I think so. I think you have to do the charging document and then you have the 30 days for a response, but the commission can give more time, give less time.
Right.
It's up to you guys. And then after that, well, it says after receipt of the answer, it kind of gives you guys another opportunity to assess the situation and to determine if you still believe that there's a violation. And if there still is a violation in your minds, then you proceed to the hearing part.
So we sent her the document I wrote, right? So it's not a surprise on how we came out on this. If we have to do a charging document, which I'd like it to be one sentence, not all the citations, et cetera, to lower the temperature level is what I'm trying to do. It seems like this is getting a little spun out of control for this kind of situation. Carrie, would that work?
I don't know what your guys' charging documents have looked like in the past, but I would imagine that they're, if it's a standard typical charging document, it's not going to be something that's going to be very wordy and extensive. You just maybe want to give her an opportunity to sort of provide an answer. So let's say if June 2nd, I don't know how many weeks that is, 2 weeks from now? Is that 3 weeks from now?
3 weeks, I think.
Just about 3 weeks, yeah.
To give her, 2 or so, or maybe even those 3 weeks to provide that answer, and then give yourselves an opportunity to kind of proceed with the hearing, but make sure that you get the answer from her before the hearing. Because it seems, well, I don't want to kind of speak on what her mindset may have been, but it still complies with the rules of procedure, but allows for the hearing to go on as scheduled so that you're not necessarily delaying that any further.
Right.
And then in the future, you guys will have to sort of take into consideration when there's a situation that arises for an expedited process. Do you want to put something in your rules of procedure or the code that allows you guys to sort of put out, and I kind of spoke briefly to Jim about this, put sort of like a stay on the person's actions until you make a determination, for example, saying, until we have our investigations, we've received this complete, until we, reach a conclusion to our investigation, we would advise that you not participate in any conversations related to the subject matter or whatever it might be. So it sort of is advisory.
Which is a cease and desist advisory. Or could
Well,
be
which-
order.
Which
Yeah,
is in our charging, which is in our what was in our procedures. It's in section 5. Sorry, C5.
Yep.
yeah.
Ugh.
So that part it seems like it already kind of captures the expedited.
Yeah.
Right.
Yep.
So that's already covered. So do we send her a charging document along with the complaint?
Well, the complaint should have been provided before the investigative procedure.
That is correct. And we did it after the fact.
So she's already been provided with the complaint.
Yes.
Okay.
Okay. So now we just need to do a charging document and, say, or was the letter we gave them the chart? No, it can't be. It didn't say charging document. Never mind.
I think we could do a quote, we could make the notice of hearing to include a charging document sentence or two. I would like to keep it as simple as we could. But then again, this particular person is going to, if she doesn't like our determination, is going to nitpick us totally.
On process.
but her only option, if she doesn't like our decision, is to appeal it to the courts, which is difficult. There is no appeal process for our determinations. Am I right, Carrie?
No, like internally, no, like she wouldn't be able to appeal it and go to the Board of Appeals or something like that, or the Civil Service Board. I'm not sure that there's a direct appeal process, even, I'm just checking the code really quick.
I think it's in 100 or someplace around there.
Yeah, so she could, well, no, that's you guys.
My recollection was she could only appeal to the district court.
Yeah, so Big David has said that a number of times.
David, you're muted.
It would be circuit court.
Circuit
Sorry.
court.
I always,
I always look at circuit district courts. They are courts that I don't want to go near.
So I mean, what I'm seeing, and this is, again, I can look at it a little bit more in depth, but I'm only seeing that the city attorney on behalf of the commission can file a petition for injunctive relief or other relief with the circuit court. I'm not seeing a direct appellate avenue for anyone who feels aggrieved by a decision by the ethics commission. But that being said, I'm sure it's probably somewhere in here.
There's an inherent right to take an appeal from an administrative agency if there's not a statutory authorization.
Yeah. It's in the Maryland rules, I think, chapter 2 or 7.
right.
Okay, so we've found evidence of a violation. A charging document shall be prepared, which may include the complaint itself, and sent to the respondent. So let's cross all those Ts. Let's go back and do that exactly right. And then we have the hearing.
Can we do it in the notification of hearing? The key here is that she's requested the hearing.
And you guys also want to consider whether you want to include a cease and desist order. I have no idea if there's agenda items before this particular commission that's going to address this in between now and June 2nd. But that's something that,
I don't think the order is necessary from the standpoint she's been advised very specifically of her conflict of interest that we determined. And based on that, she certainly is not going to participate in any further debate. That was clear in our advisory opinion.
Yes, but the advisory opinion is not valid.
Well, but she is on notice of the prior advisory opinions of
Yep.
the commission. So if she have the chutzpah to ignore those, she does so at her own risk.
Yep.
I think we were, in the opinion that was issued, we were relatively kind to her. If she chooses to ignore us, I would certainly be in favor of a much more aggressive tact.
Right, because our procedures say may include cease and desist.
Yeah, I don't think we need to do that right now.
Yeah.
Without hearing, if she has a bad attitude at the hearing, well, maybe.
Well, we could rule right after the
Right.
hearing.
Right.
So can
So
we
Jim,
put,
you're
can we put it-
comfortable putting the, sort of the charging, information in the notice?
yes, I think that's the way we should go. Does anyone think we shouldn't do that?
Well, by the complaint itself and sent to the responded by mail, electronic mail, or any other manner as approved by the chairman.
And that has been done.
Right, so no, well, no, I'm not saying that if the commission determines that there is an evidence of violation, a charging document shall be prepared, which may include the complaint itself and sent to the respondent by mail, electronic mail, or any manner as approved by the chairman. So the chairman has the approval, according to our procedure, can say it can go anywhere. It doesn't have to be mailed, doesn't have to be delivered. You can just put it in the hearing notice.
I like that.
Yep.
The charging document may contain less otherwise. Yeah, if we get the agenda out, the respondent shall have 30 days to file a response with the charging document. Unless the commission directs otherwise. So if the commission is directing that there shouldn't be no response from then we can just move forward. And she has the right to any information as requested. So she has already requested information. Right?
Yeah, there are other things that say, she has to be advised of her right to be represented by counsel, and counsel can attend the hearing. There's some sort of, there are a little bit of catch-alls that probably need to be included in that charging document or in the notice of hearing that's in the rules of procedure. You want to sort of marry up and make sure that they're included.
Yeah, and we've had those statements in prior charging documents. So Jim, you have all that in your
Unfortunately, I don't remember ever doing a charging document.
Oh, we did one for the port wardens. We've done them. Actually, Ashley helped us write them.
Okay, that was a very obvious conflict of interest.
What?
The case you referenced.
Right, but it was very public, let's say.
By the way, this is a public meeting, so.
Yeah, I know.
And recorded, so I don't think we've done anything that's out of.
No, I was just saying it was the last cases have been, we were, that all that information was put out there. So we did it, so.
Are we in agreement to go forward with the notice of hearing to include a charging statement? I'll say a charging statement in lieu of a charging document. A document to me refers to something that's separate from the notice. I'd like to include it within the notice.
Makes sense to me.
Yep.
Kara, are you okay with that, not calling it a charging document?
Why are you gonna ask me that question?
Well, I'm not, so that's why I'm asking.
I just,
I would say the charging document is the notice.
Okay,
You can put in parentheses, you can put charging document / notice.
Yep.
Are you good with that, Eugene?
Yes, I am. I like that suggestion.
Um, Why don't we leave it to Eugene and myself to draft the notice? And the hearing will be on June 2nd at 5:30.
and are we remote or in person? I'm just curious.
I think we'll do it remote. I don't feel, I don't feel comfortable not doing it remote.
yeah, boards and commission meetings are still being conducted virtually without any sort of indication as to when they may be back in person. So they're
Yep.
also still trending virtually. Jim and Pagine, if you want, I can ask Ashley about previous charging documents and have her send them to me, and I can email them to you guys if you want to use those as sort of like a template or a reference. I'm happy to do that.
That would be great.
Yeah, that would be good. Is there any further discussion on the procedures for conducting our business? I would like to task that review on what I see as two opposing views here, one David and one Kevin. Could you guys work together on doing that? And Pagine, you've had experience trying to follow it. Maybe it's in your interest to work on that, but I do think it should be a subset of, in lieu of all four of us at this point.
What are you looking for, Jim?
Review and suggestions, changes to the procedures.
Well, you know what my opinion is.
That's why I'd like you to work on it.
Well, I can. You're asking me to revise something that I don't want to exist.
Well, maybe you can convince us.
Well, maybe we should start with that. Let's start with, what are our requirements to have this?
Pros
Because
and
I think-
cons.
Right. But I don't think that it's obviously, we already made a decision that we were going to table this until we got through this particular.
I guess we did make that determination.
Right, so let's get through this next meeting. Let's get through the
Financial disclosures.
financial disclosures. We're gonna get something on the new task force. I know that's gonna happen. So I'm sorry, does this task force charge with making recommendations to modify the ward boundaries before the next election?
So let me see. It has finding and recommendations together with drafts or revisions to the charter or city code shall be submitted to the city council no later than 6 months after its establishment. So 6 months after April. What's that? October?
Yeah, everybody's going to be doing redistricting over the next several months.
Oh, yeah.
Yeah, but we have an election in November.
Oh, this November.
Yeah.
It's a little late for them to get started.
Yeah, that was
Well,
sort of.
there's- Keep in mind, isn't there also a primary?
The primary is in September.
September.
Yeah. So the shadows for me are lengthening.
Yes.
I love that statement.
That's what Douglas MacArthur said in his farewell speech at West Point as he was on his way out of here, literally and figuratively.
So if somebody's already made waves about it, they're going to make more waves about it, and we're going to be on it really fast. So I would say let's let's review after, have a meeting to talk about high level goals after we finish this particular particular complaint, the revisions to the code, and the financial disclosures.
Okay,
So I think
I don't believe there's anything else on our agenda. Is there any further discussion on this issue? Gene, you and I will work on getting the notice.
Jim, tomorrow my schedule's really packed, so if we could maybe talk on Wednesday?
That's even better for me, yes.
Okay, great.
just since we were just talking about the election, I just wanted to remind the commission, my fellow commissioners, that I am a treasurer for a candidate in this next election. There's no conflict, but I just want to make sure you're aware of it.
We appreciate that.
Thank you.
So when are you going to run?
I am decided that I do not have the required amount of empathy to be a politician.
I love it.
Yeah. Many of them don't either.
Being a chair of a nonprofit in a tumultuous time was enough for me.
Yes. We understand.
I was one of the only one-year chairs in a very long time in that organization, and 1 year was way long.
Must have been a doozy.
Uh, Do I hear a motion to adjourn?
So moved.
Second,
Any discussion? Those in favor? Aye.
aye.
The time is
6:22.
6:20.